Why should you care about contract law? Well, contracts, money, show me the money, right? This is all about business and commerce and deal making. So contracts are very, very important. They have perhaps an undeserved reputation for being boring. They're not boring. I mean, they're not necessarily jump out of your seat exciting, unless you're, maybe on the receiving end of a large contract with a lot of money behind it, okay? So let's jump into contracts a little bit. And I'm going to give you the definitions, which you need, but I'm going to give you plenty of examples as well. And I'm happy to answer questions, of course, and I'll try to give you some examples from my own life and my own practice about contracts. But my guess would be that every one of you guys probably signed a really important contract at some point in the last month or so, or you're getting ready to, and that's a contract for your housing. Okay? So a lot of you guys are sophomores, juniors, upperclassmen, and you might be getting ready to sign, or you may have signed a lease agreement for an apartment next year, or maybe you signed a contract with the university for housing, room and board kind of thing. That's a really, really important contract. It's most likely a 12-month contract, and it's going to have a lot of application to how you live your life in the next year. And so we're going to have some talk about lease contracts and what you can and cannot have in there, because as we go through this, you might be surprised to find, if you sign a contract with one of our highly reputable local apartment companies, that there might be some illegal provisions in there. So I might just be able to give you some practical knowledge that could save you a little bit of money down the road. Okay? So contracts, what are these? Well, essentially they're agreements. Okay? And they are generally going to be an explicit agreement. We'll talk about some ways in which a contract can arise from conduct, but typically you're making an agreement with another person or with a company or with a university or whomever the other party is, usually a private party, although the government can make contracts as well, but we usually think about this with private parties, and you're making some kind of agreement. Very often it's going to be in writing, but it doesn't always have to be. I'll show you a couple examples of oral contracts as well. When we talked about torts, we talked about duties that exist just because we live in society, okay, and because we have certain expectations and because courts have ruled that we have certain duties, like if you own a store and it snows, you have to shovel the sidewalk outside so people don't slip and hurt themselves, okay? You don't have a contract with passerby. That's just a duty that arises out of belonging in society and according to precedent. Now contrast that with a contract where you've got no existing duty with this other party to do whatever the subject of this is, but you create that duty. You say, why would you create a duty to someone else? Well, you're getting something of value in exchange, and in fact, one of the hallmarks of a contract is both parties are getting something of value. If you don't have that, it's not a contract, okay? So it's a statement of the rights and the promises that the parties make to each other, and it's going to be a statement of what value is exchanging hands, okay? This can be as simple as you probably had some lunch today, and at some point you probably bought that, whether you went to a restaurant or whether you brought food from home that you bought at a grocery store. All right, that was a transaction. Now, you didn't sit and write out a contract, but you exchanged things of value, right? They got your money, you got your food, okay? We're mostly going to talk about contract law in the lens of state law and common law, okay? There are instances in which breach of contract suit could get into federal court, primarily if you've got people or companies from different states and you've got over $75,000 in play. That could get you into federal court. But most of the stuff we're going to talk about is state law. And common law is an important thing in contracts. I'm sure there is and yeah, in fact, there is some statutory law about what contracts can have and not have. Like, for instance, we'll talk about the Uniform Landlord and Tenant Act, which is a section in the state code that says you can have certain things in a lease, you cannot have certain things in a lease, okay? That's statutory law that affects contracts, but a lot of this is common law too. Okay, contracts are a very old concept, and as long as people have been making deals with each other and negotiations, I suppose things have been going wrong, and judges have been asked to rule on that. Okay, so we have a lot of case law that says this is what we do in this situation with this kind of contract. This is what we do in this situation. Okay, so I had a situation where I was representing one of my clients who's an athlete, and he hired a personal trainer in past years to do some work with him. Okay, when I came on board as the lawyer, I said, you know, this had always been kind of a informal deal, and I said we should have a contract to protect you. It should set out all the rights and responsibilities of both sides, because this personal trainer was known to be, to put it gently, a bit of a problem sometimes. So I did the contract, had it approved, sent it over to the lawyer for the trainer. He looked at it, got really angry, and said, no, we're not going to sign your stupid contract. And he sent his own contract back. A lot of it was handwritten and crossed out, and I said, no, this looks like something a child did. We're not going to sign that. I didn't say that, but I thought that. We never did get together on a written contract, because we sent ours back and said, if you want to work with us, this is what you have to sign. So the trainer just flies out and shows up and says, I'm here, I'm ready to work. And we said, but you haven't signed the contract. Will you sign it? No, I'm not signing anything. We said, pay for your plane ticket, but you got to go home now. So he threatened to sue us on the basis of an oral contract. He said we had a deal. But there's a case in Iowa that says you cannot have an oral contract and a written contract for the same transaction. And I said, we have a written contract. You just failed to sign it. Here is this case. Now, leave us alone. And they did. Okay, so that's an example of common law that you kind of have to know if you work in this field. You kind of have to keep up on these decisions, or you have to be able to go out and research them. All right. The reason that we have laws around contracts is to provide some stability and predictability. So you might be saying to yourself, how does a judge even get involved in private disputes between people? Okay, well, this is actually a good thing for public policy, because if you didn't have the ability to enforce contracts in court, what would your remedies be? Fighting, stealing from the other person, combat dolphins? These don't look so good, okay? So we tend to think this is a good thing. And the court tries to apply what is called the objective theory of contracts. In other words, they're going to look at what is written before anything else. The judge and the jury are less interested in what you thought about the contract. Okay, so that's going to start to make more sense. Now, there are cases where a mistake can creep in and a person's belief can influence it, but generally they're going to look at the contract first, more than what you say you thought. So our elements. We've used this phrase elements a lot. We've talked about the elements of a tort, the elements of a crime. Well, these are the elements that a contract has to have for it to be enforceable against someone, okay? And if you are going to court to enforce a contract, as the plaintiff, the burden of proof is on you to show these things. First of all, you have to show there was a contract, okay? Now, again, in the vast majority of cases, we're looking at a written contract, not an oral one, although there are some cases where that could apply. But then, once you show there was a contract and that the other side didn't live up to their end of it, which we're going to talk about, called a breach, you have to show that the elements of that contract were there and that they're properly done. So I think it's good if you found a way to kind of recall these 5 elements when you get down to exam time, or when you're signing a contract, or you're designing a contract. Shouldn't be necessarily writing contracts on your own, unless and until you get to law school and pass the bar, but you could kind of think about what you want in there and have it drafted, okay? So we're going to talk about the agreement itself, the consideration, and then we're going to talk about capacity, which has to do with the people involved in the transaction. We're going to talk about legality, which is the subject of the transaction. And then we're going to talk about genuine consent, which has to do with the people as well. So if you're a visual learner like me, I tried to find some pictures that would summarize this. Agreement, the handshake. Consideration, the money. Capacity, the little kid with the contract in front of him. And legality, got some drugs there. And I'll give an example of why that doesn't work out for contracts. So let's think about the agreement part first. Because if you don't have this, essentially the analysis stops. To make an agreement, you got to have offer and acceptance. All right? Where you're going to see these terms in your life verbatim is when you buy your first house. Some of you guys maybe have bought houses already. Okay? For me, it was after I got out of grad school and I bought my first house. Then these terms, offer and acceptance, are going to be the terms you use when you're negotiating that purchase. Okay? If you can get both of those, then you've got the agreement part, okay? And then that feeds into the contract. There's going to be other ingredients, too, that are needed. But first of all, somebody's got to make an offer. Either an offer to sell, or an offer to purchase, an offer to do some work for some money, or maybe an offer to pay you some money for some work. Those are kind of the most common things that I can think of, okay? So if you are going around the neighborhood and you see house for sale sign, and you look it over and you say, I think I'd like this house, what's the listing price? And they tell you it's not an offer yet, they're just advertising the price. But then you will sit down and you'll use a written offer sheet and say, I will pay you whatever, $200,000 for your house, and here are the terms. We'll close in 6 months. We'll pay this much up front. We'll have financing by this date. Whatever. There's a whole lot of things you can put in there. All right? But you give that offer to the other side, and then they have a chance to accept it. Okay? And if they do accept it, then you've got the agreement part. Now, there can be a whole lot of diversions and missteps on the way to that, though. So there's some things that you should know. A price quote is generally not an offer that can lead to forming a contract. So if you see, I don't know, like for instance, I like outdoor stuff. I like fin and feather. So if I saw a thing where they said, we've got fly rods, $100 or less, this week, and I go in and they're all sold out and I have the advertisement, can I sue them for breach of contract? No, it's a price quote. Didn't say they were going to sell it to me. They weren't making an offer to me. It was just kind of a general, here it is, okay? Price quote or an advertisement, not usually an offer. Why do we even have to say this? Well, with all kind of warning labels and disclaimers, somebody tried this. In the old days, people would sometimes try to sue a store if they didn't have the product they wanted. Okay? And in fairness, a lot of those stores use manipulative advertisement to lure people in by having only one of a product for sale very cheap, and then they did a bait and switch and said, well, we'll sell you this other thing. Okay? So it's not like lawsuit happy customers necessarily. It was some shady stores as well. Putting an item up for auction is not an offer in and of itself. It's a request for an offer. Okay? You've got to have definite terms in the offer. Okay? It's got to be definite enough to allow the other party to accept on those terms. So if I go up to you and I say, man, you have a nice car, I'd really love to buy that someday if you ever get tired of it. And then 5 years down the road, you decide, I'd like to sell that car to him. And you say, call me up, I accept your offer, we have a contract. And I say, but I've already bought 2 new cars since then. Well, too bad, suing you for breach of contract. Doesn't work that way. Not definite enough. Okay? So a definite offer tells who the parties are, buyer and seller, or worker and employer, whatever that may be. The subject matter, what the contract is about. The consideration, we'll talk about in a minute, that's the value exchange. And a time for performance. So you saw in that example I gave, a pretty open-ended discussion and then someone trying to form the contract 5 years later. That doesn't really make sense, does it? That's not really reasonable. So a good offer that allows someone to accept is going to have a time requirement in it. When you go to buy your first house, there's going to be, at least in Iowa, on the standard offer sheets, it says what time the offer expires, and you might give them 48 hours to accept or counter. If you get an employment offer from an employer, generally it's going to say you've got 2 weeks to accept this offer, or a month, or whatever. Okay? So counterexample to this, there's kind of a famous one, or it has to do with a lost dog and a poster. And this has to do with the idea that in order to form a contract, the offer has to get communicated to the person who's trying to be a part of that transaction. Okay? Suppose you're out walking around Iowa City and you find a dog running free. And you look at it and it's got a collar and it's got the owner's name and number on it. And you call them up and say, hey, I think I found your dog. They say, oh, that's great. You know, here's where I live. Please bring him back. And you do. You say, great. You know, thank you for bringing my dog back. Now, suppose you're leaving their house happy. You've done your good deed for the day. And then you walk by a poster on a telephone pole. And you see the picture of that same dog that you just brought back. And it says $200 reward for safe return of this dog. Okay? And you think, oh my gosh, $200, I could really use that, right? So you go back to the person's house and you say, with the poster, you say, I brought your dog back. Can I have my $200, please? All right? Now, what the ethical thing to do there is, I don't know. That's going to be something that you have to think about. But legally speaking, since you didn't know about that offer, you can't enforce that contract against the person whose dog you found. Okay? Because it was never communicated to you. All right? So always look at posters first. That's the moral of that story. Now, the moral of the story is do the right thing. But in that case, not enforceable. Sometimes people get a little bit cute with their language. And this can get them into trouble. So I told you that there is such a thing as an oral contract. All right? I'm going to give you a limited set of circumstances in which only a written contract will do. But you can create a contract verbally. All right? So this nice lady, her name is Jody Berry, and this was in the early 2000s, and she worked at the Hooters restaurant. I was calling it a restaurant is maybe a little kind. She worked at Hooters. And if you know anything, because I have a friend whose former girlfriend used to manage one of these, but they have lots of sales contests where they incentivize the employees to sell as much beer and soggy wings as they can. And then they win stuff, okay? Sometimes it's money or merchandise or whatever. So there's a lot of competition that goes on within the restaurant. And the manager of this Hooters, which was in Florida, got all the servers together and said, we're having this contest. Whoever sells the most beer during the month of whatever, I don't know, April, is going to win a Toyota, a new Toyota. Okay? See how fast I said that? So everybody's like, yeah, this is cool. You know, I could use a car. Who couldn't use a new car, right? No more was said. So Ms. Berry went out. She sold a ton of beer. And the manager had a little ceremony then said, okay, Ms. Berry is our winner for the month. They blindfolded her, took her out to see her new Toyota, which was a Toyota, which now might be worth something, but at the time, not so much. And she was not amused, okay? She was not amused. And so she pursued a case against the manager in the restaurant for a breach contract. She said, look, you promised whoever did this would get this. I did that. I worked extra hard to do this. Now you've got to come through with it. So Hooters, of course, get sued a lot for a lot of reasons. They're no stranger to the courtroom. But they said, well, we don't think we should have to pay up. It was a joke. News came out a little bit later that they settled the case. It looks like about a year later. And the attorney for Ms. Berry said he could not disclose the settlement details, but it was enough that she could go to a local car dealership and pick out whatever type of Toyota she wants. So a favorable settlement. I think Hooters probably knew that if they went to court on this, not only would they have a good chance of losing, it was more bad publicity, okay? This looks like a picture from a press conference. When you can make a sad face like that, that's not good press. They have enough image problems, okay? So I guess what you have to be careful about is if you try to trick someone, it could actually come back on you in the form of that contract. Now, a jury would have had to decide, was there a meeting of the minds, which we'll get to, but essentially she did everything that was asked and then some to try to get there. So we talked about offer. Now, acceptance. How do you accept an offer that's made to you by the other party? Well, there's different ways this can occur. Generally, you've got to do something affirmative, though, okay? Say something, sign something, take some kind of action. We don't allow like a negative implication kind of thing. It doesn't happen too much anymore, but when I was a kid, there was a sort of a company that would send you something in the mail. This was when we listened to music on CDs, right? This is a long time ago, before MP3s and stuff. So this company would send you a thing, and in the mail you open it, it said, you've been enrolled in the Music of the Month Club. You're going to get 10 CDs for a penny, and then if you don't cancel your subscription, you'll get 10 CDs every month for $190 or something like that thereafter, right? So kind of the scam was, we're enrolling you in this against your will. You've got to do something affirmative to opt out. That's not a contract, okay? You can't force somebody into a contract and say you have to opt out. There's got to be, they have to do something to accept. I can't go to this class and say, everyone in here agrees to help me garden this summer unless you write me a 5-page essay on why you shouldn't have to do that or something. Right? It doesn't work that way. You have to do something or say something to accept. We'll talk about these bilateral, unilateral contracts. It's just kind of a fancy term for how is the acceptance done. Bilateral, you're like, hey, want to make a contract about this for this amount of value? And say, sure, I'd love to make a contract with you about this for that amount of value. Let's do it. Okay? Unilateral is kind of like, I'll pay $10 to anybody who can tell me why people walk through the back of the room at almost every class period. I actually know the answer. They're visiting students. But that would be a unilateral contract, and you'd accept through performance by yelling out, they're visiting students. They're potential Hawkeyes, okay? Then I'd have to pay you. You did something, though. And if the offer is unclear as to how you can accept, you can probably accept either way. Now, these common law contracts are bound by what we call the mirror image rule. So remember I was telling you that an offer has to be definite enough to accept on its terms? That's what the mirror image rule tells us. So if I say to you, I need some gardening help this summer, I'm willing to pay $15 an hour, and I need you for 20 hours a week. Okay? You can accept, or you can reject, or you can counter. But what you cannot do is say, I accept your deal for $20 an hour and 30 hours a week, because you varied the terms, right? You don't get to do that. The offer and acceptance have to be mirror images at common law. So this is going to apply to stuff like real estate contracts and employment contracts, most importantly. All right? We're going to have this chapter on the UCC talking about businesses and selling goods to each other, and there's some leeway there. This rule is modified and waived in some cases when it's a business-to-business kind of deal. But the general rule is you've got to accept on the terms or you're proposing a counter. So I had a student who's an MBA student, and he graduated and wrote me. He's like, I have this job offer. They're offering me, X number of dollars with this much vacation and this start date. He's like, I have a trip booked already to Colombia. I paid for my ticket. It's non-refundable. I can't do it on that start date. They don't seem really willing to negotiate. Can I, write back and say I accept, but subject to this date? And I said, you can if you wish. It serves as a counteroffer. That is a rejection of the original offer, and they don't have to make you a new one. And in this case, they actually did withdraw the offer because they said we needed you at this day. He was prepared for that. That was okay. All right. So an offer can lead to acceptance in an agreement, or it can terminate the process of forming a contract as well. And how can that happen? Well, one is just flat out rejection. Okay? I say to you, I'd like to buy your house for $100,000 and I'll close within 30 days. And you say, shove off, my house isn't for sale. I reject your offer. Okay? Very clear. Very obvious, right? You don't have any duty to make a counteroffer. If I want to make another offer, I can. But you can tell me the same thing if you want. Another way to reject and to cut off the process is a counteroffer. Like the example I just said. You come back with different terms. That's a counteroffer. They don't have to honor the original offer because you've rejected it and you've proposed a new offer. So that's important to know. And the person who makes the original offer could change their mind before you accept. And they could revoke the offer. So maybe you get a letter that says you've been accepted to Harvard Law School, okay? And we're filling the class of 2018, so please get back to us as soon as possible. And you wait 3 months, and then you call them and say, okay, I guess I'm ready to maybe join you. Not sure. And they say, we're Harvard. You're not sure. We're withdrawing our offer. Could do that, right? Revocation is effective when you receive notice that the offer's been pulled back. So we used to have a lot of discussions about the mailbox rule and what happened when acceptance and revocation of an offer cross in the mail. I don't think anybody under 70 uses the mail anymore for business. Having worked at a law firm where a lot of people are over 70, I can tell you it still happens. Most stuff is going to be email these days, so we don't really need to get into that. But, in the odd chance it crosses, there are some old rules which I'll go into if you want. I don't think it's a big deal anymore. But it's generally when the offeree receives it. And it's got to be before you accept, okay? So if you get that letter from Harvard, it says, we want you to join our class 2018 law school, you call up and say, I accept, I'm in. And they said, oh man, we were just drafting a rejection letter. We found somebody better. Tough. I'm coming. Get ready. Expiration or operation of law. These are other ways that offer can terminate. So if the offer comes with a time limit, we're going to offer you this job working for us. You're going to make this much. You're going to get this much vacation. Start date is this. We need to know if you're going to join us within 2 weeks. That's the period for which the offer is open. If you blow the deadline, too bad. The offer has terminated. Okay? If it's got no time limit written, then you have a reasonable time in which to accept. What is reasonable? It's going to depend on the kind of offer and what it is. You'd have to look to the case law to see what the norms are there. Termination by operation of law. This can happen if there's a lapse of time. So kind of similar to the first one. We would think about it more often in these last three, which is something happens to one of the parties. Either they pass away or become not able to legally form a contract. Maybe the subject matter is destroyed, like you're trying to buy a classic car from somebody and it falls off the car trailer and is destroyed. They don't have another one to replace it. That would be a termination, right? Or some kind of change in the law that now makes the subject matter illegal. And we'll kind of get into all these in the voidable and void contracts discussion. So let's talk about consideration, the value aspect of this, okay? As we move from agreement toward contract, we're at this stage. So let's assume we have an offer, we have an acceptance, they're legally sufficient to form an agreement. Now, before we can analyze whether we've got an enforceable contract, we've got to look at, is there consideration going both ways? Because an enforceable contract has something of value changing hands between the parties. It's not just a gift from one to the other. All right? Because when you get into situations like that, I'm going to show you some examples where we talk about, okay, is this a gift? Is it a contract? Famous case. This is Mr. Sidway. He was a weird guy. He was an odd uncle, okay? And, well, actually, I don't know if he was the uncle or the nephew. But the case is Hamer versus Sidway, okay? And so you've got an uncle. And his nephew is about to go to college. And I don't know what kind of advice you guys got from your uncles before you came here. But this is different advice than I got from my uncles. Because his uncle says, don't drink, don't swear, don't play cards. My uncles taught me to do all those things, right? Some of your guys probably did too. But he says, don't drink, don't swear, don't use tobacco, don't play cards, don't play pool for money until you reach 21. And if you do that, I'll give you $5,000. Now, this is old-timey. That's a lot of cash. And the nephew was like, geez, uncle, those were the things I was thinking about doing when I went to college. And at that time, the drinking age was lower, or perhaps non-existent. Okay, so he had a legal right to do all those things if he wanted to. But he said, I'm going to give it a try. And miraculously, he went his entire college career without doing any of those things. Obviously did not go to Iowa. Right? And so he gets out of college, he's a graduate, and he says, dear uncle, I've come to collect my $5,000. I've lived this life of purity for the past 4 years. Now I need to go buy booze and cigarettes. No, he didn't probably say that. But he said, I'd like the money. Well, lo and behold, his uncle has passed away. All right? And this was written in a contract, and as part of his uncle's estate, okay? So this was an obligation in writing, and the note, aka the contract, was assigned to a third party named Hamer. Okay, so this is Sidway, I'm sorry. This is the guy who doesn't drink or smoke. He looks really old for 21, but that's what not drinking will do to you, I guess. No, so he goes to this guy who now owns the contract that the uncle used to own, and the claim is denied. All right? The claim is denied. And so the question is, is giving up those things a legal form of consideration? Because what's the thought here? Okay? The thought is, it was good for you to do all those things. Okay? You probably got better grades. You graduated. You might not have done those if you'd been drinking and smoking and gambling and doing all these things. All right? So they said, we don't think there was any consideration. It's not a valid contract because I got nothing. The uncle, who's now dead, got nothing out of this, right? He didn't. What could he have got out of it? Well, it was you who wasn't doing these things, and those things helped you, all right? And so the court looks at it and says, consideration can be anything that somebody might want to bargain for. And so going back to this one, essentially judge's thinking is that that's a weird thing that you did, but obviously you got, as an uncle, you got something of value. You got like the warm, good feeling that your nephew was out there being safe and not doing these things. We don't understand why you were willing to pay $5,000 for that, but you bargained for that. It had some value to you. Therefore, we're going to uphold the contract. Okay? So this was a legal contract. So one way to find consideration is, did you give up something for the benefit of another, right? Even if it's something that you had a legal right to do. So if you come up to me and said, you know, Andy, I'll give you $5,000 if you don't drink coffee for the rest of the semester. I will laugh in your face because that's worth way more than $5,000. But if I fulfilled that, we'd have a contract, perhaps. Okay? So consideration is anything of legal value that comes through a bargain for exchange. Now notice it doesn't say financial value. It doesn't say anything about it being a, quote, good deal. Courts will regularly enforce contracts where somebody was a bad negotiator and maybe they didn't get as much value as they should have for whatever it was they negotiated. But they don't really care about the sort of goodness of the bargain. What they do care for is that there's something that somebody could value. So if you promise to do something you've got no legal duty to do, if you perform some action you're under no obligation to do, right? If you refrain from doing something that you have a right to do. All of those things can be consideration. And the court's not going to look into, is it adequate? They're just going to look, is the sort of are the bare elements there? So could you run into a problem with consideration if I'm telling you that it's just the bare elements? Well, yeah, there's some situations I can think of. Past consideration can't form the basis for a contract. So suppose, and this happens to me all the time, suppose you write me a couple years from now and you're like, Intro Law changed my life for the better. I am making so much money because of what I learned in there. I'm going to send you $50,000 next week. And I say, great. And then I check my mailbox and your check doesn't arrive. Is there a contract that I can force against you? No, because you were considering sending that money in consideration of something I already did, which was teach you way back when. Don't let it stop you, from just sending checks in the future, but it's not a contract, okay? Pre-existing duty. Sometimes you might have a situation where there's a contract in place already. Like, I used to paint houses, and so we would do a bid, and it was a firm price quote. Say it's $4,000 to prep and paint the house. Now, maybe I get going, and I realize I screwed up. This is going to take way longer. I should have charged you more, okay? If you are willing to form a contract that pays me additional money for work that was contemplated in the first one, we've got to add some consideration on my side as well, or it's not enforceable, okay? So in other words, I can't just do an add-on that says same amount of consideration going to you, which is to prep and paint your house, but more money for me. That second part, not going to be enforceable. So what would we do? We'd add a little bit of work, or we'd add some kind of change order, something like that. That one doesn't come up a whole lot. Capacity. This has to do with the people in the contract, the parties, okay? So assume that we've got our agreement. Assume that the consideration is adequate. Now we're going to look at, can these folks legally make a contract together? Okay? Capacity is the legal ability to enter into a contract. And there are certain times when two people or two parties might write a contract and sign it, but there's a defect there. And if one of them goes to enforce it later, there could be problems. All right? So let's talk about these different situations. Minors, in other words, people under the age of 18 in the U.S. Can they sign a contract? Well, physically, they could sign the piece of paper, but can it be enforced against them? Generally not. Okay? So, as an example, a lot of you guys probably grew up in Iowa, and it's not that uncommon for teenagers in Iowa to work farm jobs, and they can make a decent amount of money, and maybe to buy a pickup truck, right? So if you're 17 and you've been working on farms and you have enough money to make a down payment on a truck and finance it through a dealership, can you do that? Well, you can. Now, what if you stop making payments? Can the dealership sue you and get the truck back and keep your money? That's where the problem comes in, okay? If you're not 18, you can't be held to a contract. Now, it doesn't mean you get away totally off the hook, okay? In that situation, if you missed your payments, you could be let out of that contract. In other words, it could be voided, or you can disaffirm and you don't have to make future payments, but you do have to make restitution, which would entail giving back the vehicle, and if you damaged it somehow, you might have to make payments on that. Okay? So it's not like a totally get out of all your obligations free, but the onus is really on the other party to determine, hey, is this person 18? Can they sign a legally enforceable agreement? And if they can't, then they know they may not be able to enforce that. Or they may say, we need your parent to sign this instead. Okay? So in all of these cases, when I talk about, getting rid of a contract, getting out of it, writing a new one, there's sort of a general fairness principle that underlies all these, which says we're not going to unjustly enrich one party at the expense of the other. There's going to be they're going to have to make amends as best as possible. Okay, so I don't want you to think these are the, quote, loopholes that can get you rich. What about intoxication and mentally incompetent persons? So here's a couple folks who are doing a bit of drinking. All right. The old Icon used to have a way to post anonymous questions, which was a hell of a lot of fun, let me tell you. Because I had a great question. Somebody said, I went to Vegas last week, and I think I got married. I don't know, because I was pretty drunk. What should I do? Well, stop drinking, first of all, but get a handle on that. But, I said, I'm not licensed in Nevada, but I'll look it up. And there are some laws out there that perhaps unsurprisingly deal directly with the issue of drunken marriage. But sort of the general common law contract rule is that if you're too drunk to understand the consequences of a contract, it's not going to be held against you. And marriage, among other things, is a contractual relationship, so there might be a way to unwind that. All right? If you buy a car when you're drunk, if you sell your house when you're drunk, you may have, if you're to the standard where you are not competent to make that contract, you may be able to unwind that deal, having, of course, to make restitution. I think if you read in your book, there is a case where a court upheld the sale of a farm, though, because the people were drinking, but they couldn't prove they were so drunk that they were incompetent. So it's a pretty high bar, all right? If someone is judged mentally incompetent by the law, maybe they have a guardianship because they have a mental difficulties, or they're very old or very young or something like that, they are probably not allowed to do their own contracting. The court and the law has appointed someone to watch over them, and that person has to give their consent as well. So every now and then you hear about this in the context of some salesperson taking advantage of an elder person. All right? In any of these cases, if you're going to raise these defenses to the contract, it burdens on the person raising the defense. Okay? Legality. The courts have seen, in my opinion, too many cases in which people sue their drug dealers for breach of contract. Okay? There are examples right from Iowa City of people calling the police because they thought they got ripped off by their drug dealer. I wouldn't recommend that, okay? I wouldn't recommend filing suit in civil court either for breach of contract. Because anything that's prohibited by statutory law, like crimes, drugs, things like that, that cannot form a valid basis for a contract, all right? You cannot legally make a contract to buy illegal drugs. You cannot legally make a contract with a hitman to kill your business rival, okay? The courts say, we are not going to come in and enforce your shady business, okay? You're not going to use our court system to help you with your illegal subject matter, all right? Get out of here with it, all right? So statutory law, things, tortious acts. So you try to hire somebody to steal trade secrets from a competitor, right? You try to hire somebody to interfere with a contract between supplier and purchaser. Those are tortious, right? Hire somebody to defame your rival. It's not going to be a contract that can be enforced through the courts. Some of the other issues that you might see are anti-competitive contracts. So antitrust, this is the monopolies, right? Every now and then, like for a long time, the hard liquor industry got together and they made an agreement with each other that we're not going to advertise on TV, because if one of us advertises on TV, then we all have to. But if none of us do it, then we can save money. Okay? Well, what if one liquor company decides we're going to do it anyways? Can you sue them for breach of that agreement? No, that's an antitrust violation. That's a monopoly, right? Anti-competitive behavior. Non-compete agreements and employment contracts. The courts will enforce some of these, and some of them they won't. So you might be generally aware of what a non-compete agreement is. It's if you sign a employment contract, sometimes it will say, and you agree for a period of 1 year not to go work at another business of this kind in Iowa City, for 1 year or something like that. All right. Sometimes chefs sign them, software engineers, salespeople. It can be any walk of life, really. Now, if it's narrowly done and it makes sense, within the terms of the industry, courts may uphold those. However, I've seen some really stupid ones too that say, you agree that if you leave our company, you will not work anywhere in the world for 5 years. It's anti-competitive. It's against public policy. Courts are not going to enforce that. This is an interesting one, and it's changed a little bit with the news. Martin Shkreli, the pharma bro, who had at least one fan here last time. Somebody was like, woo! Okay, maybe that guy's in jail too. This fellow's now in jail, but at the time when he was free and had money, that wasn't going to lawyers, he executed a contract to buy a private album from the Wu-Tang Clan. They put their album for sale. It was not released. No one had heard it except them, and I suppose their producer. And they said, we're making an offer to sell this album for $2 million. And he accepted and bought the album. The contract for sale had a really interesting clause. And it had a clause that the Wu-Tang Clan may legally plan and attempt to execute one, heist or caper to steal back the album. And if successful, it would return the ownership rights to the group. And the rights to steal the album extended only to the active members of the Wu-Tang Clan and or the actor Bill Murray. I guess just for irony, maybe. So is this a legal provision in the contract? I tend to think not, I guess. I guess it depends what your definition of heist or caper is, but that sounds a lot like burglary, which would be illegal. Now, as it turns out, Shkreli's in prison. He's going to bankruptcy. It looks like the album is going to revert to the group, so they may be able to release it, or perhaps they will sell it again. We might get to listen to it. So, kind of an interesting thing. There are other ways little illegal things can creep in to contracts, and you wouldn't necessarily know it unless you're familiar with some of the laws around this, okay? So I have seen many lease contracts that say if the landlord, if you don't pay your rent and the landlord has to sue you, they can not only collect the back rent and penalties, but you also have to pay their attorney's fees. This is a common provision in leases around here. Problem being, it's specifically prohibited by the Iowa Code, right? Says you can't do that. So if your landlord attempts to enforce this against you and they win on the back rent issue, they try to collect the attorney's fees, the court is going to say, no, you can't do that. And there may be other penalties as well. So different types of contracts, let's just take a quick look at these. We talked about the bilateral versus unilateral, how you accept those. We talked about express versus, we will talk about express versus implied in fact, and executory and executed. This kind of just reinforces the example I gave you a minute ago about that. Express and implied. Almost every contract that is going to see the light of day is going to be an express contract. Okay, these are the ones where the promises are very clear. The terms are stated, okay? Implied in fact happens through the conduct of the parties. All right, so say you have a business and you're standing outside by your plate glass window and a window washer comes by and he says, your window's pretty dirty. And you're like, yeah, it is. He's like, well, I could clean that. And he's cleaning it. He's talking about the service and the rates. And he gets all done with it and says, all right, it'll be $5. And you say, whoa, 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 whoa. We were just chatting. I didn't expect to pay you for the clean window. Court might say, now, who goes to court over a $5 window? Nobody, hopefully. But court might say, yeah, you kind of knew what you were getting into there. He's a window washer. He's cleaning your window. You didn't try to stop him. You're talking with him about possibly, engaging his services. Got to pay the guy. Okay. Possibly. I don't run into a lot of cases with implied contracts, okay? Executed versus executory. Well, pretty simple here. If it's executed, then the job is done, whatever it is, whether it's a contract. In this case, I'll use the example of building a house. Is it performed? Has the builder finished building the house? Or is executory, is it in progress? All right? So progress is being made, but it's not all the way completed. Some special rules of contract law that we should know. Statute of frauds. Contracts that must be in writing to be legally enforceable. Why we call this the statute of frauds, I don't know. It should be called like the statute of contracts that need to be in writing. That would be much more clear, okay? It's a weird word. You have to know it. So this sets out what kind of contracts have to be in writing to be enforceable. And these can vary a little bit from state to state. I'm giving you kind of the general majority viewpoint here, and I believe Iowa's statute of frauds is similar, if not identical. But generally we think about, is it a contract for the sale of goods over $500? Okay? If so, and if one party intends to enforce it against the other, it's got to be in writing. So you can make an oral agreement to buy something for $10, and that could be enforceable. But if it's over $500, it's got to be in writing. Anything involving an interest in land, so real estate, we just feel it's so important because of the rights that are transferred that it's got to be in writing. Okay? Any contract that cannot be fully performed within 1 year has to be in writing because it's a big obligation. Okay? Those are the biggies. So $500 in goods, land, and multi-year contracts. These other ones are kind of old-timey. Made in consideration of marriage, made by an executor, promise to pay another person's debt. I wouldn't worry too much about those. The first two and the last one are the biggies. Now, what about when maybe you don't have everything that you need in there for a contract, but you've got some of it and you're looking at a very unjust result if the bargain cannot be enforced? Well, here we look at sometimes what's called quasi-contract. So not all the required elements of a contract are there, but one party would be greatly disadvantaged, okay? And here's that term I talked about before, unjust enrichment. Courts don't want one person getting wealthy at the expense unfairly of another. So suppose you're sitting out in your lawn and you see your neighbor planting a row of bushes or trees, and you can tell that she thinks she's doing it on the property line on her side, but you know the property line is actually in a little bit different place, and she's planting them on your land, and you're like, yeah, free trees, great. Just going to sit back and let this happen. Just watch this go on, you know? And later on, she's like, yeah, did you see those trees I planted on my land? And you're like, you mean my land, right? Those are mine now. Okay, is that fair? It's a weird thing to argue about, but no, it's kind of like, in that situation, a court might say, okay, you got a bunch of free stuff. You didn't do anything to deserve it. You've got to pay part of the cost. All right? So these things, there's a case, and it's still going on, but there was an appeal here in Iowa City. It had to do with some property out by one of the highways where somebody knew that another party was building a restaurant on their land, on the bystanders. The guy in the lawn chair was like, oh, that guy's building a restaurant on my parcel of land. That's going to make me a bunch of money one day. And he waited and just, you know, the restaurant got built and it opened up and they're like, all right, this is my restaurant. And they're like, what do you mean? And you're like, well, you own that lot, not this one, and you built it here. And then litigation by both sides ensued, and the Supreme Court was basically like, really? So the merits of it are still going on. There was a big fight over attorney's fees. Promissory Estoppel. This is kind of, again, where you got the situation, maybe you don't have all of the required elements of a contract, but you got an unjust enrichment or someone's been led along very much to their detriment. So Red Owl Foods, I don't know if this is still a thing, but in the 60s, they were sort of a franchise operation, okay? And you could purchase from them the ability to open up your own grocery store under their brand. And you had to satisfy certain requirements, like how much cash you had on hand, and you had to have proper location for it. You had to own the land and things like that. So you've got the plaintiff here where he's in long, ongoing conversations with the parent company about buying a franchise, okay? And he does a lot of things to move toward that, and they keep telling him, okay, it's looking good, we're moving towards a deal. Okay, so he moved to a whole new town because they thought this would be a better town for you to have a grocery store. He put down money to buy the land. He restructured some of his finances. Okay, he did quite a bit. Red Owl kept changing the terms, and eventually they never did sign a contract. He claimed promissory estoppel. In other words, you guys made a clear and definite promise. I relied on it substantially, and justice would be better served by enforcing this promise. So in this case, the court said, yeah, you have to sell this guy the franchise. You've taken all these steps. He's done everything you said. Just because you sort of dropped out or attempted to drop out at the last minute doesn't mean you get away totally scot-free. So that's the first part of contracts. We'll come back next week and we'll do some more.